This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to the Luxembourg Fundcast. Welcome to the deep dive. Today, we're really diving deep into something crucial, the legal documents behind mergers and acquisitions here in Luxembourg. Our game. To cut through the jargon, give you a clear path to understanding the key bits, non-disclosure agreements, letters of intent, share purchase agreements. We'll look at everything from those first hush-hush talks right through to signing on the dotted line for ownership transfer. We'll unpack their legal routes, talk negotiation tactics, look at costs, timelines, and, importantly, how the changing regulations are shaking things up.
Right. And by the time we're done, you should have a really solid grasp of three critical ideas. First, the hybrid nature of Luxembourg law. It's unique. Our M&A practice blends the old civil code foundations with, very dominant Anglo-Saxon deal customs. Understanding both sides is just vital for good negotiation and, frankly, managing risk. Second, the power of intent. Especially in those early documents, like an LOI, Luxembourg law really focuses on what the parties meant. So sloppy drafting. That could turn your non-binding roadmap into a binding contract you didn't bargain for. Precision is key. And third, those new regulatory hurdles. Things like foreign investment screening, foreign subsidies, they've really changed the game. Timelines, risk allocation, they're now major strategic points right from the start.
Okay, let's unpack that first point then. To really get these documents, we need to start with the ground they stand on, the legal framework. And in Luxembourg, it's quite a mix, isn't it? The absolute foundation is the civil code. Some core bets go way back to Napoleon, 1804. It's still the default framework for agreements here. So that's the core concepts for everything else.
Exactly. And out of that, three principles really stand out in M&A. First, freedom of contract. Article 1134 basically says agreements made legally are law between the parties. So you're generally free to set your terms, even pick a foreign law if you want, although there are limits, mandatory laws, public policy rules, that sort of thing. Second, good faith. Same article, 1134, says contracts must be executed in good faith. And importantly, Luxembourg courts push this before the contract, too, into the pre-contractual phase. It implies this duty to negotiate fairly, honestly. You can't just string someone along.
Which sounds like it leads straight to your third point, pre-contractual liability. So if talks get serious, like really advanced, and one side feels a deal is basically certain, pulling out unfairly can lead to trouble.
Precisely. It stems right from that good faith duty. If negotiations are so far along that one party genuinely, reasonably believes a contract is happening and the other side just walks away wrongfully, well, they can be sued for damages. It's usually under Article 1382 of the Civil Code that's tortious liability, something to definitely keep in mind during those early chats.
Right. So how does this basic setup shape the actual deal process? It seems to dictate a pretty logical sequence. You start with an NDA non-disclosure agreement to protect sensitive info, then maybe an LOI letter of intent to sketch out the main terms, and finally the big one, the SPA share purchase agreement for the binding deal and ownership transfer.
It's a natural progression. And it's not a static system either. Luxembourg is actively modernizing its contract law, the law of obligations in the Civil Code. A committee started work back in July 2023 with support from the University of Luxembourg. They're looking at recent reforms in France and Belgium, countries with similar legal roots. The idea is to codify things currently set by case law, like that pre-contractual liability and good faith we mentioned, to make things clearer, more certain legally. It's a big deal for how we do transactions.
And this is where it gets really practical for anyone doing deals here. You've got this old principle-based civil code, let's be honest, not designed for massive, complex share deals. And then you've got the very detailed, almost prescriptive Anglo-Saxon style M&A agreements that international investors prefer. It creates this tension.
A tension, yes, or maybe a hybrid reality. A typical Luxembourg SPA looks very Anglo-Saxon in structure, but it has to be interpreted through the lens of the civil code. So common terms like warranty or indemnity, they might not mean exactly the same thing here as in London or New York. There can be subtle but important differences.
So the role of Luxembourg Counsel becomes critical then, acting as a sort of translator.
Exactly, like a bridge between two legal cultures. You need someone fluent in both, ensuring that the internationally styled contract actually delivers the intended commercial result without tripping over unforeseen consequences under local law. The upcoming reform might narrow this gap a bit, but for now, navigating that duality is absolutely central.
Okay, let's move to the first real document in the process, And the non-disclosure agreement, or NDA. The gateway, you could say. It's the binding contract setting rules for handling sensitive info in those early stages. You absolutely need one before any serious due diligence starts.
And in Luxembourg, it's become quite powerful, largely thanks to the 2019 Trade Secrets Act. This law implements an EU directive and gives NDAs real teeth beyond just standard contract law. Before this act, proving damages from a breach was, well, tricky. Now, if information qualifies as a trade secret, meaning it's secret, has commercial value because it's secret, and crucially, you've taken reasonable steps to keep it secret.
And the NDA is a key reasonable step.
Precisely. A well-drafted, properly managed NDA is Exhibit A for showing you took reasonable steps. And that unlocks much stronger remedies under the Act.
Stronger how? What kind of remedies are we talking about?
Things like court orders, injunctions to stop the misuse of the information, or even orders to recall or destroy products made using those secrets. It really shifts the NDA from just being a defensive shield to potentially being an offensive sword. But again, the info has to qualify, and you need that robust NDA to prove you protected it. Makes negotiating the NDA a pretty strategic exercise from day one.
Makes sense. So, breaking down a typical NDA, what are the key bits? The definition of confidential information is obviously central. Seller wants it wide, buyer wants it narrow. Then permitted use has to be strictly limited, right? Just for evaluating the deal, nothing else. And exclusions, things that aren't confidential. It's stuff already public or developed independently. Plus the core promise. The obligation of confidentiality, not to disclose except maybe to advisors on a strict need-to-know basis, provided they're also bound.
Exactly. And don't forget duration, usually negotiable, maybe 2 years, sometimes longer, for real trade secrets. And remedies for breach should state damages might not be enough, allowing for injunctions. And critically, remember other laws interact with the NDA. First, GDPR. If personal data like employee lists are shared, you need specific GDPR clauses covering the lawful basis for sharing. Second, competition law. If the buyer and seller are competitors, you have to be super careful. Sharing sensitive commercial data pricing costs could easily breach Article 101 of the EU Treaty. The NDA needs to be structured to prevent any anti-competitive info exchange. It's a fine line.
Right. So once the NDA is signed and there's clear interest, parties often draft a letter of intent, or LOI, sometimes called a term sheet. It sketches out the main commercial points after some initial digging. Sort of a non-binding roadmap for the final SPA.
Yeah, its main job is alignment, making sure everyone's on the same page on the big ticket items price structure, key conditions before committing serious resources to final due diligence, and drafting the massive SPA. So check in.
But here's where it gets tricky, that binding versus non-binding piece. An LOI should be non-binding on the main commercial terms under Luxembourg law, but it's not automatic.
Not automatic at all. There's a real risk. A court here can decide an LOI is binding if it looks like the parties intended it to be. They'll look for the essentials of a contract, clear agreement on the thing being sold, and the price and language showing intent.
And this is where the infamous promise of sale trap comes in.
Exactly that. Article 1589 of the Civil Code says a promise of sale is equivalent to a sale once there's agreement on the item and price. If you accidentally use that specific legal term, promise of sale, in your LOI, even if the rest says non-binding.
Uh-oh.
Uh-oh is right. You might have just created a fully binding sale obligation on the seller. It's a classic pitfall.
So the absolute best practice is
Crystal clear language. An explicit clause stating unequivocally that except for specific carve-outs like exclusivity or confidentiality, the document is non-binding and creates no legal obligations until a final SPA is signed. Spell it out. Don't leave any room for doubt. So an LOI effectively has two parts: the non-binding roadmap, things like transaction structure, share or asset deal, indicative purchase price, clearly stated as indicative, subject to due diligence, and maybe a high-level list of conditions precedent. And then the binding rules of engagement for the negotiation itself. The big one here is usually exclusivity. That's the seller's promise not to shop the deal around for a set period. Gives the buyer security to spend on due diligence. It's standard and enforceable. You'll also usually bind confidentiality, often just referring back to the NDA, maybe costs. Each party bears their own, it's typical. And definitely governing law and jurisdiction to make sure those binding bits, especially exclusivity, stick.
So the LOI isn't really a mini SPA, it's more strategic. It's about controlling the process of getting to a deal. For the buyer, that exclusivity is gold. It stops an auction situation after they've shown their hand.
Yeah.
And while we have that good faith negotiation duty, the LOI kind of formalizes the seriousness, right? While keeping flexibility on price until all the facts are out.
Exactly. Think of it as a contract about how to negotiate. It de-risks the process for the buyer. But navigating that binding versus non-binding line, especially avoiding the promise of sale trap, is critical.
Okay, so we've navigated the LOI, due diligence is complete. Now we hit the definitive stage. The share purchase agreement, the SPA, the final binding contract. This is where it all comes together.
It absolutely is. But before we dive into specific clauses, there's that fundamental structuring choice. Share deal or asset deal. It impacts everything in the SPA. In a share deal, the buyer buys the target company's shares. The company itself continues, worse in all assets, liabilities, contracts, history.
Meaning the buyer inherits everything, including potentially unknown problems.
That's the risk, yes. Caveat emptor, buyer beware, is the starting point. But transactionally, it's often simpler, just transfer the shares. And crucially, in Luxembourg, it's usually very tax efficient. Share transfers are generally exempt from registration taxes and VAT. That's why it's the dominant structure here.
So why consider an asset deal then, with those potential tax hits?
Flexibility, mainly. The buyer acquires only specific assets and maybe assumes specific liabilities directly from the target company. You can cherry pick what you want and leave unwanted baggage behind. But it's much more complex logistically. Each asset needs transferring according to its own rules. Real estate needs a notary. IP needs specific registrations. Contracts often need third-party consent to be transferred.
And the tax downside
Can be significant. Asset transfers, especially real estate, can trigger registration duties, maybe 6 or 7%, plus a possible 1% transcription fee. That potential tax bill often drives parties back towards a share deal, despite the inherited liability risk.
Got it. Now, SPAs are often huge documents. Let's focus on the key clauses that drive the deal and get negotiated hardest. Obviously, sale and purchase the core promise to sell and buy the shares, free from liens or claims. Then purchase price and adjustments. How the price is paid, and often mechanisms for adjusting it after closing based on final accounts, usually secured by holding back some cash or using escrow. And if there's a gap between signing and closing, you have conditions precedent or CPs, things that must happen for the deal to close. Regulatory approvals like competition or FDI screening are big ones now.
Right. And then you get to probably the longest, most fought over section, representations and warranties, or R&Ws. These are pages and pages of detailed statements from the seller about the company, its legal status, financials, contracts, tax compliance, litigation risks, IP ownership, everything. They do two main jobs. One, they force the seller to disclose any known issues up front through a separate disclosure letter. If it's disclosed, the buyer generally can't sue later for breach of that specific warranty. Two, they allocate risk for the unknown. If a warranty turns out to be untrue and it wasn't disclosed, the seller has essentially given a contractual guarantee and is liable for the buyer's losses under the indemnification clause.
Which brings us to indemnification. This is the remedy clause, right? How the buyer gets compensated if an R&W is breached or if a covenant is broken. It's the buyer's main protection after the deal closes. But seller liability isn't unlimited, is it? There are usually caps and baskets.
Almost always. Seller liability is typically limited by time, a period after closing when claims must be brought. Often 18-24 months for general business warranties, maybe longer, like 5 to 7 years or even more, for fundamental things like title to shares or for tax issues. And by money, there's usually a cap, a maximum total amount the seller can be liable for, often tied to a percentage of the purchase price, and a basket, a threshold below which claims can't be made or are handled differently.
What kinds of baskets are there?
Two main types: a deductible or excess basket, where the seller only pays the amount above the threshold, or a tipping or first dollar basket, where once the threshold is hit, the seller pays the entire claim amount, right from the first euro. Negotiating those limits, the time periods, the cap percentage, the basket type and amount is where a lot of the SPA negotiation happens. It's pure risk allocation.
So pulling off a successful M&A deal here is definitely an art form. It's this blend of precise legal work, sharp negotiation, and managing commercial risk. Where do the main negotiation battles usually happen?
Well, early on in the NDA, it's about the scope of information and duration. In the LOI, the big one is usually the length of the exclusivity period. Seller wants short, buyer wants long to complete diligence. But the real heavyweight negotiation is almost always in the SPA, focused squarely on those representations and warranties and the indemnification mechanics, the scope of what's warranted, how disclosure works, and especially those liability limitations. Caps, baskets, time limits. That's where the financial risk really lies.
And what about the costs involved in getting a deal done? It's not just the purchase price.
No, definitely not. You have legal fees, often structured as a mixed, be a fixed fee for early stages, then a success fee percentage linked to deal value, payable only if it closes, or sometimes it's hourly rates. Then notarial fees if real estate assets are involved, often percentage-based. But the big variable, as we discussed, is registration and transcription duties. Share deals, usually exempt in Luxembourg. Asset deals, especially with property, can trigger those hefty duties, up to 7 or 8% combined. That tax difference massively influences deal structuring here.
And the timeline. How long does a typical private deal take?
Oh, it varies hugely depending on size, complexity, and regulatory hurdles.
Yeah.
But you can think in phases. Phase 1, prep and initial contact, maybe 2 to 4 weeks. Phase 2, LOI and preliminary due diligence, perhaps 4 to 8 weeks. Phase 3, negotiating the SPA itself, another intensive 4 to 8 weeks usually.
And then the gap between signing and closing.
That's phase 4. And it's become the big variable. Historically, it might have been short. Now, with regulatory approvals needed, it could be anywhere from a week to, realistically, 6 months or even longer. This is where those new regulations really bite. This is what some call juridification hitting the timeline. Mandatory regimes like the Luxembourg FDI screening law and the EU's Foreign Subsidies Regulation, FSR, insert compulsory waiting periods. You have to file, and you have to wait for the green light before you can close certain deals. It creates significant regulatory risk. Who bears the risk if the regulator says no or imposes tough conditions? That's now a major SPA negotiation point. You might see clauses like hell or high water, where the buyer promises to do almost anything to get approval.
So that uncertainty impacts everything: financing, how long exclusivity needs to last.
Yeah.
The timeline becomes a risk map. So looking ahead, it's clear the landscape keeps shifting. We've mentioned the FDI screening law from July 2023. That's a big new step for investments in critical sectors here. Need that Ministry of Economy okay before closing. And the EU-level Foreign Subsidies Regulation, FSR, from October 2023, adding another layer of review for big deals with non-EU government backing. Plus the Cross-Border Mobility Directive, implemented here in February 2025, updating rules for EU mergers and divisions, adding more creditor and shareholder protections. And hovering over all this is the ongoing civil code reform, aiming to modernize fundamental contract law. Lots happening.
Absolutely. And navigating all this complexity successfully, it really demands specialized local expertise. Counsel needs to master that hybrid system, fluently bridging the civil code and international M&A practice. They need proven skills in regulatory process management, guiding clients through those complex, time-consuming FDI and FSR approvals. That's now table stakes for deal certainty. And deep structuring expertise is key, knowing how to use Luxembourg's flexible company law, vehicles like the SARL, SA, AS, combined with our huge tax treaty network to build efficient cross-border structures. It's about making the system work for the deal.
Great points. So let's quickly recap the 3 critical takeaways for listeners from our discussion today. 1. Remember the hybrid system. Luxembourg M&A blends civil code roots with international practice. You need to understand both. 2. Intent is paramount, especially in early documents like LOIs. Be precise in your drafting, or non-binding might become binding. Watch out for that promise of sale language. And 3, those new regulatory hurdles, FDI screening, FSR, they are game changers for timelines, risk, and cost. Factor them in from day one. So perhaps the biggest thing to keep in mind for your next Luxembourg deal is that it's not just about the financials. It's about skillfully navigating this unique legal interplay between deep-rooted tradition and modern global practice. This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Hit that like and subscribe button. It was the Luxembourg Fundcast for you today.